what does it mean to be the fulcrum security? And I'm glad we've gotten to this question because it's a pretty important part of Chapter 11.
Yeah. So let's look at the example first. Company's worth $10 million. Secured lender is owed $9 million. And valuation, it says it right on the side. Value is in the eye of the beholder. Quick frolic and detour for like a hugely important point. Valuation can be everything in a Chapter 11. A lot of important outcomes occurred because there were two experts who took the stand, one for the secured lenders, one for the bondholders, one for the bondholders, one for the equity or the debtor, two competing valuation experts, and they testified based on their valuation report that the company's was worth X or the company was worth Y. Let's assume that there is no let's make the very unrealistic assumption that there is no question of value. It's stipulated that a company is worth $10 million and that a secured lender is owed $9 million. So, and the unsecured creditors are owed $5 million. It doesn't take an actuary to figure out that there is really no value left for equity. Equity is out of the money. In fact, the unsecured creditors are out of the money because there's $1 million left to pay $5 million of claims. Now, equity can try to make a deal with the unsecureds where they consensually agree to allow equity to stay in place and agree to a plan over which would pay the unsecureds in full over time, or less than full over time. People can agree to whatever they want to agree to. But if the unsecureds do not agree, they can end up owning the company. And because that's the reality, whether they end up owning it or not, but given what this math is, this math makes, in this example, these unsecured creditors the fulcrum security. That's what the fulcrum security is. It's the point in the capital structure that if where the money runs out if you're going to distribute based on strict priority of distributions.
And as a result, those people can have a lot of power in a bankruptcy situation.
That's right. That's right. There's a parenthetical in the first bullet point that is, I guess it's related because it's on this slide, but related or not, it's a point that I want to make. Getting back to pre-packs and pre-arranged, generally speaking, a pre-pack and a pre-arranged is thought to deal is generally considered to be the medicine you need if you need a balance sheet restructuring. If your business is fine and you don't need to use other powers of the bankruptcy code, like the power to reject bad leases that you don't want and executory contracts you don't want, then the pre-pack is a good goal to strive for. However, that's not the same as saying that in the context of a pre-pack, you can't do some of those things. Just like you can get bondholders or a bank around the table, you can get landlords around the table. So that's just one point I wanted to make. And then the other piece of this parenthetical is when there's an indisputable fulcrum security, that means that it's going to be an easier pre-pack. And again, it all comes down to value. If there's fundamental disagreements about where the fulcrum is, then there's not going to be an agreement pre-petition. The parties are going to, take their chance with what the judge says, because they're going to argue over value.